Hello everyone, my name is Caden, and today I'll be evaluating the terms and conditions, also known as the user agreement, for Priceline.com. I'll start by briefly summarizing each section from Part 1, Sections A through F. Then I'll address several key legal questions about the agreement before sharing my recommendations and concluding thoughts. Section A, Arbitration and Dispute Resolution. Section A discusses resolving disputes through arbitration, a private dispute resolution process. Priceline's Terms of Service explicitly states, any and all claims must be resolved by binding arbitration or in small claims court. They also want to remind you that joining a class action lawsuit or similar group proceedings isn't an option. If you find yourself in a dispute, you must address it on your own and not as part of a larger lawsuit against Priceline.com. They encourage you to provide a written notice to customer support to resolve the issue. This informal step is important before proceeding with arbitration or small claims court. Section B, Disclaimer of Warranties. Priceline disclaims all warranties regarding the accuracy, reliability, or completeness of information, the timeliness of any material, and the services on its site. Simply put, Priceline.com does not guarantee error-free content or that it will meet expectations. The user agreement also provides content on a as-is basis and clearly disclaims warranties of merchantability, the state of being fit for market, fitness for a particular purpose, and non-infringement. Section C, General Limitations of Liability. This section limits Priceline's liability for damages from using its website or services. According to their terms of service, as permitted by law, neither Priceline.com nor its covered parties, officers, directors, employees, affiliates, suppliers, and others are liable for various damages including loss of goodwill, profits, or damages from site access limitations, unauthorized access, errors, or transactions. It also clarifies that travel service providers are independent contractors, and covered parties are not liable for their actions or omissions. This distinction between Priceline itself and actual travel providers is a key aspect of their liability limitation. Essentially, if something goes wrong, like booking error, Priceline.com's financial responsibility to users is strictly limited. Section D, Indemnification and Chargebacks. Section D states that users agree to indemnify, reimburse, or compensate Priceline for any losses or damages resulting from their site's misuse. The agreement also addresses chargebacks, stating that users may be responsible for costs if they dispute charges without a valid reason. This indemnification section requires you to defend and reimburse Priceline.com and covered parties against claims by you exceeding the liability limit, or third parties due to your breach of the agreement, violation of the law/third-party rights, or improper site use. The credit card chargebacks section outlines scenarios they consider improper, including chargebacks on non-cancelable reservations, those authorized by third parties, those arising from inconsistent supplier descriptions, or those due to force majeure, unforeseeable circumstances. Essentially, Priceline.com retains the right to dispute such chargebacks and recover costs from you. Section E, Trademark and Copyright Notice. For Section E, Priceline.com asserts its ownership over the intellectual property on its site, including trademarks, logos, and copyrighted content. Users are not allowed to use this material without permission. As I'm using their content for educational purposes, using their logo or site screenshots is not likely to get me into trouble. Or will I be liable? I'll get into browse wrapping later. Section F, Claims of Copyright Infringement. Finally, Section F outlines the procedure for informing Priceline.com under the Digital Millennium Copyright Act, DMCA, if you suspect your copyright has been violated. The user agreement includes specific guidelines on drafting a written notice of claimed infringement and specifies the various submission methods via snail mail, email, or fax. Question 1. Is it a valid contract? For a contract to be valid, there must be an offer, consideration, and acceptance. Priceline.com's terms and conditions are generally considered a valid contract if users are given clear notice and an opportunity to accept them. However, enforceability depends on how users are made aware of these terms. If users browse the site without actively agreeing, known as a browse wrap agreement, courts may not consistently enforce the terms. Stronger legal protections come from a click wrap agreement, where users must affirmatively click I agree before proceeding. Question 2. Are visitors bound to it, or should they have to click I agree? Visitors are most securely bound to the terms and conditions if they must click an I agree button. This is the standard for click wrap agreements, which courts generally uphold as binding. If Priceline relies only on passive notice, browse wrap, users may not be legally bound, especially if they are not required to take affirmative action to indicate agreement. The best practice is to have users click to agree to the terms, especially prior to purchasing or setting up an account. Question 3. If I have a dispute with Priceline, can I sue them? Why or why not? Under Section A, users cannot bring most disputes to court. Instead, disputes must be resolved through binding arbitration, or in some cases, small claims court. Additionally, users are prohibited from joining class actions against Priceline.com. This means you generally cannot sue Priceline in a traditional court. For most issues, you must use arbitration. Question 4. What changes would I recommend? For my first recommendation, I would require explicit agreement. Priceline should ensure that all users, especially those making purchases or creating accounts, affirmatively accepts the terms and conditions via a click wrap agreement. Next, there needs to be a clearer notice for the arbitration clause. The arbitration and class action waiver should be presented in a prominent, easy-to-understand format, possibly with a pop-up or a highlighted box so users cannot miss it. Then, I suggest that Priceline also provide more user-friendly language. Plain language would make the agreement more accessible to the average user. Afterward, I recommend a change in terms management. When terms are updated, Priceline should notify users via email or a prominent website/in-app notice and require re-acceptance of the new terms. A summary of key changes would also help users understand what's different. In a blog post, Eric Goldman provides strong legal justification for this, highlighting the risk of clauses that allow unilateral amendments without notice, thus rendering the entire contract illusory and unenforceable. He explicitly advises, and I quote, in all caps, "Stop putting clauses into your contracts that say you can amend the contract at any time, at your sole discretion, by posting the revised terms to the website." Goldman's advice is based on the risk of the entire contract failing, based on the Harris v. Blockbuster Inc. case. Remember Blockbuster Video? Those were the days. In 2009, a Blockbuster customer alleged that Blockbuster's reporting to Facebook violated the Video Privacy Protection Act, which prohibits the disclosure of personally identifiable information, PII, without consent. This case stems from the legal fallout of Facebook's Beacon program, which reported purchases from third-party e-commerce sites to the user's Facebook status, requiring these sites to send purchase information to Facebook. You can probably imagine how that went horribly wrong. Lastly, I recommend further transparency in liability and indemnification. Priceline.com should clarify the scope of reimbursing the site and the process for chargebacks to prevent misunderstandings. Conclusion and final thoughts. To summarize, Priceline.com's terms and conditions are generally structured to protect the company, particularly through arbitration and liability limitations. While these provisions are standard in the industry, enforceability hinges on how users are notified and whether they actively consent. Requiring explicit agreement and improving clarity would strengthen Priceline's legal position and enhance user trust. Thank you for watching. Please comment below if you have any questions or want to discuss further.